Good afternoon and welcome to the webinar, Legal Considerations to Start or Grow a Business in Germany or the US, presented by Arent Fox Schiff partner Baron Romagnolo and Evershed Sutherland counsel, Dr. Michaela Feliciak. Please note that this webinar will be recorded and is closed caption enabled. In order to turn your closed captions on, please select Show Captions located in the toolbar at the bottom of your screen. Additionally, we have reserved time at the end of each section for a Q&A session, and we ask that all questions be submitted through the Q&A feature located at the bottom of your screen. If you have a case-specific question, we ask that you email Baron or Michaela directly. All contact information will be shared at the conclusion of the webinar. A recording of this webinar will be shared with the audience in a follow-up email. And now I would like to introduce Baron, who heads the Arent Fox Schiff Business Immigration Practice, as she kicks off the webinar.
Hi, everyone. Thank you for joining us. Dr. Michaela Feliciak is with me from the Germany side, and we're going to be doing a webinar on both sides, how to start and grow a business in Germany and how to start and grow a business in the US. We'll start with the US side for 1 hour, and we'll run through a list of topics for you to consider as you're starting to grow your business or start a business in the US. You'll see on the first slide the topics that we're going to be covering and the order we'll be covering them. And then I'll turn it over to Germany, and Dr. Michaela Feliciak will take over there, and she'll go through a similar list for 1 hour from the German side. Let's kick it off from the US side. The first topic is the corporate presentation by Paul Schmidt. He is a partner in our corporate group, and he'll be talking about the corporate considerations to think about when you're starting a business in the US.
Thank you, Baron. And hello, everybody from Boston, Massachusetts, where the autumn colors are starting to appear on the trees. I'm going to speak about the corporate and governance considerations when forming a new business in the United States. Next slide, please. A critical component to consider for U.S. businesses is what's called the corporate veil. And if legal entities are appropriately formed and governed, the liabilities of the business are separate from the owner's liabilities. And so in the US, it's very important for the liabilities to not be imputed on the owners, such that any problems with the business remain with the business. And so I'll speak a little bit about how to maintain this veil between the corporation and the shareholders. Next slide, please. So for starting businesses in the United States, there are two buckets of options. There is a sole proprietorship, which has no distinction between the business and the individual. And the second bucket are separate legal entities. And here are 4 options for what type of legal entity they can be. So we do recommend, in order to keep the liabilities with the business and not have them be assumed by the owners, that all business owners in the United States form a legal entity and not stay with a sole proprietorship. So one question after deciding to form is where to form. The business has to be formed in one of the 50 US states. States such as Delaware and Nevada have become quite popular because of their business-friendly laws, but a business owner can choose to pick any one of the 50 states. It is very typical, if Delaware or Nevada are not chosen, to choose the state where the business has its principal operations or its headquarters. And it is also required, if you form in a different state, for example, Delaware, but your main operations or significant operations are in other states, such as Massachusetts, to register to do business there. After forming and after choosing the entity type that of the legal entity, it's important to follow the corporate formalities such that the liabilities of the business stay with the business. And those are filing the necessary paperwork to form the entity, having bank accounts that are separate from the owners and not commingling funds between the individuals and the business. Having the assets and liabilities in the name of the business, and also signing contracts and other documents in the name of the business and not in the name of the individual. All of those steps will help the legal case that any liabilities of the company are not imputed on the owners. Next slide, please. So if you have a partner who you're starting a business with in the United States, we always counsel those partners to talk about what's called the owner's agreements. And these are the major items regarding the governance of the business. And these are often put into an agreement, could be called a shareholders agreement, or could be called an operating agreement, to describe how the business will be governed. And some of the major topics that are considered in this are how are funds put in and how do funds come out of the business. If the business needs more money, are the shareholders required to put it in, or is it optional? When can a distribution of profit be sent to the shareholders? Another major topic is who is in charge of the day-to-day decisions of the business? Who also is in charge or has a voice in the major decisions of the business? Often common examples of major decisions are the business to incur debt or decide to sell the company. And lastly, another major topic of conversation for the owner's agreement is the transfer of equity. If one partner wants to leave the business, what are his or her ability to do so, and what are the restrictions on selling or transferring their equity? Next slide, please. I hope you all remember the hit movie called Jerry Maguire, featuring Tom Cruise, in which he shouted through his 1990s era cell phone, "Show me the money." And of course, money is an important part of a new business venture. And the funds for that business venture can come from a variety of sources. One source is debt financing, which can come from a bank or also a private lender. Those lenders will require collateral for providing the loan to the business. The collateral could be the cash flow of the business, or it could be the assets of the business. If you're starting a new business and it doesn't have cash flow or assets, the bank may require a personal guarantee of the owners. Capitalization for the business can also come from equity financing, which is investment from owners, whether they be the operating partners or from outside professional investors. And the type of entity that's chosen and the terms of that investment will depend upon what type of investor you're receiving. When forming the business, deciding whether to take on debt financing, deciding how or when or under what terms to take on equity financing, taxes is a driving component of those decisions. And so that's when I help our clients with forming a business. We always do it hand in hand with our tax colleagues in helping make the correct decisions. And Jean, our colleague, is going to speak a little bit about tax considerations.
All right. Thank you, Paul. So taxes are, obviously a key thing when it comes to showing the money. That's absolutely a key consideration. So, in the interest of time, we'll go ahead and jump into the next slide, please. So what's key from a U.S. tax perspective is understanding that our system of taxation is quite complex. You have various taxes that are imposed at both the federal level, mostly administered by the IRS, but also state, local, county, municipal levels, and there's sometimes overlap among and between the various taxes. Therefore, it's important that before undertaking any sort of tax planning, that tax advice be obtained from a professional tax advisor before starting a U.S. business. And then once the business is started, to keep in contact with the tax advisor as the business is run. The closest touch point will typically be an accountant, but sometimes you may need to get a tax attorney involved as well to provide tax advice on an ongoing basis. In particular, if an expansion of a business is being considered once it's been established, or if there's a merger or acquisition, any significant distributions, all of those can implicate tax considerations. Next slide, please. But once you're starting a business, the choice of entity is important. In the US, because of our check the box system, which I can get to in a minute, there is some flexibility in terms of choosing an entity for corporate purposes and then how that entity is taxed. So choice of entity on this slide reflects the various entity types that are recognized for tax purposes. First, you have corporations. On the one hand, there are C corporations, which are separate taxpayers and fiscally opaque. By default, when you create a corporation under state law purposes, it will be a C corporation. In certain cases, you can elect to be a so-called S corporation or a small business corporation. Those are synonymous. It's a separate taxpayer. However, it's taxed on a pass-through basis. There are certain restrictions, though, with an S corporation that are not present with a C corporation. So an S corporation is limited as far as the shareholders that it can have, which typically need to be U.S. individuals, trusts, estates. In certain cases, tax-exempt organizations can be shareholders as well. There are also limitations on the number of shareholders that an S corporation will have. For most taxpayers, an S corporation may not be the most appropriate choice, but in some cases, it does make sense. Next is the category of partnerships. These are typically pass-through entities that are separate taxpayers and have two or more owners. Finally, there are disregarded entities. These are also pass-throughs that have only one owner, and for U.S. tax purposes, at least for U.S. income tax purposes, I should be more precise, they're treated as a sole proprietorship or a branch or a division of its owner. Next slide, please. So I mentioned that there are the so-called check-the-box regulations under U.S. federal tax law. These provide a great degree of flexibility in terms of classifying an entity for tax purposes. There are certain companies, such as corporations, specifically those that are incorporated under state law, and certain types of foreign companies that are so-called per se corporations. They have to be taxed as corporations, cannot elect any different status under the check-the-box rules. But once you're outside of that set of entities, there are certain default rules that apply, but those default rules can be modified by filing an election with the IRS. So you'll find that by default, a non-corporate entity that's formed in the United States would be taxed as a partnership or would be disregarded, depending on whether it has two or more owners, in which case it's a partnership, or if it has only one owner, it's disregarded. For foreign entities, the rules are a little different, and the default status depends on whether all or less than all the owners have limited liability. So where all owners have limited liability, by default, the classification will be that of a corporation for U.S. tax purposes. If less than all owners have limited liability, then it would be a pass-through entity. Again, as I mentioned, non-corporate entities in many cases can elect a different eligible status. So just by way of example, an LLC or a limited liability company that's formed under U.S. law with two or more members, by default would be treated as a partnership for tax purposes, but can elect to be taxed as a corporation. On the other hand, a domestic LLC with only one member by default is disregarded for tax purposes, but can elect to be taxed as a corporation as well by making a filing on a Form 8832 with the IRS. Next slide, please. On this slide, we have a whole host of other tax considerations to be considered. So most of what I discussed in the prior couple slides addressed entity classifications for income tax purposes, but there are a various number of tax considerations besides that a startup business should consider. So, for instance, you need to typically obtain a taxpayer identification number. For most businesses, this will be an employer ID number from the IRS. In addition to federal taxes, there are state and local income taxes that need to be considered. These can vary widely depending on the state. So consideration should be given to where a business operates, where it derives its income. There are employment and payroll taxes as well. These are imposed both at the federal and the state and local levels in certain cases. Those should be considered too. Excise taxes can be imposed at the federal and state levels as well. Typically at the federal level, they're imposed on certain types of goods. But again, consideration should be given because there may be state excise taxes in addition to federal. Gift and estate taxes, these are imposed at the federal level, and some states have an estate tax or an inheritance tax regime too. Those should be considered in particular as it may relate to owners of a U.S. business. Typically, a U.S. business itself would not be subject to gift or estate tax. Some states impose franchise or gross receipts taxes. These are different from taxes on net income, subject to different rules, and so a business should be aware of those as it starts up in the United States. There are real estate transfer taxes that are imposed both on direct real estate transfers as well as, in some cases, transfers of interests in entities that own real property. As you can see, and this is not an exhaustive list, there are all sorts of different types of taxes. There are some taxes that are not on this list as well. They have different filing and payment schedules and requirements, which can get complicated very quickly. And so many businesses find it helpful to retain a CPA firm to assist with compliance on an ongoing basis. Next slide, please. In addition, there are further levels of complication where international tax is at issue. So, whether it's inbound where a non-US investor is investing in the United States, or outbound where a US investor is investing abroad, whatever the structure, there would be additional levels of complexity. In the interest of time, I'm not going to get into any degree of detail on international tax rules in the United States, but it is important to consider the impact of tax treaties if there is a cross-border component. There are tax treaties implicating income taxes between the United States and many other countries. There's a smaller number, but still an important subset of treaties that address Social Security taxes. And there's a handful of treaties that address transfer taxes, which would be estate and gift taxes. Next slide, please. I'll use my final minute to address the Corporate Transparency Act. This is a law that came into effect at the beginning of this year, and it requires that most entities that are formed by making a filing with a U.S. state, which could be a corporation or LLC, or certain other types of business entities, or any non-U.S. entity that's registered to do business in the United States, is required to make a filing with FinCEN, which is a bureau of the U.S. Treasury Department, disclosing beneficial ownership, among other information about the business. There are 23 statutory exemptions from reporting under the Corporate Transparency Act, which is also called the CTA, typically applicable to highly regulated entities, financial companies, public companies, utilities, and so forth. One of the exemptions to keep in mind, which is probably going to be the more common exemption for many entities to the extent that they are eligible for one, it's an exemption for large operating companies, which have to have at least 21 full-time U.S. employees, at least $5 million in U.S. source gross receipts as reported on the most recent federal tax return, and an operating presence at a physical U.S. office. While the CTA isn't necessarily tax specific, it does impact a wide swath of entities. And so businesses operating in the United States should be aware of its existence and seek to assure compliance with its requirements. And so with that, I will let the employment considerations take the spotlight. Thank you.
Thank you, Gene. All right, up next is Alex Romero. She's a partner in our Labor and Employment Group at Arent Fox Schiff. And she will talk about some of the employment law considerations if you're going to start a business here and hire people to work in the United States. One thing I want to quickly mention before she starts is that something that Kathy mentioned at the very beginning. Please put your questions into the Q&A feature at the top or bottom of your screen, and we will get to those questions and answers at the end of the US presentation. And then Germany will do the same thing. They'll have their Q&A answered at the end of their presentation. Just make sure that they're not case specific. If they are case specific, please just email us directly so that we can keep case specific information confidential. And with that, I'll turn it over to Alex.
Great. Thank you, Baron. So today I'm going to be talking about some of the employment law considerations that you should keep in mind as you're building a business in the US or expanding a business. Building out a people operation is probably one of the first and most important things that you're going to do. And it can also be one of the most complex things from a legal compliance perspective. And a big reason for that is that there are various sources of law that are potentially applicable to you depending on where you're located in the United States. So the first question you need to ask yourself is, what do I need to do to be legally compliant with federal employment laws? These are laws that are going to apply to you regardless of where your business is located, and they serve as the floor in terms of legal compliance. Federal employment law can cover a variety of topics. For example, one of the most common federal statutes is called Title VII. Excuse me. It's a law that prohibits discrimination and harassment in the workplace, and it's probably the most common source of claims that an employer gets from its employees. There are other federal statutes that are also very common. The Fair Labor Standards Act governs how employees are paid. And it can also serve as a source of claims both from an individual level and frequently on a class-wide basis. So it's very important to keep these statutes in mind as you're starting to build an employee population in the United States. But that's not the only thing that you need to keep in mind. Depending on which state you are located in, there could also be some significant additional compliance requirements, and in some states, even local requirements as well. So typically, when a company is moving into the US market, it is not uncommon for them to start in California or New York, which happen to be states with some of the most onerous employment laws at the state level, and in particular at the local level. For example, if you're starting a business in San Francisco, not only do you have to worry about federal law and state law, there are also some very unique local ordinances that you would have to comply with as well. Next slide, please. So whether it's federal, state, or local, these are some of the common topics that we see come up early on when a business is expanding into the United States. One of the first and most important ones is making sure that you are paying your employees properly. And that can include, obviously making sure that you're satisfying any applicable minimum wage requirements, which can vary, again, by state and sometimes by locality. And in addition to minimum wage requirements, you also need to be mindful of overtime requirements. At the federal level, if an employee is working more than 40 hours in a work week and they're classified as non-exempt, you have to pay them overtime 1.5 times their regular rate for every hour they work over 40. That's typically the case at the state and local level as well, but there are some exceptions, particularly California, which is going to be a common theme. As you work in the US, you know that California just does things a little bit differently. And there you have an obligation to pay overtime if an employee works more than 8 hours in a day, and different obligations if they work more than 12 hours. And in order to make the determination about whether or not you're paying someone overtime correctly, you have to determine whether they are considered exempt from those overtime requirements or non-exempt, meaning that you have to pay them overtime for those extra hours. This is an analysis that depends on a couple of factors. First of all is how much you're paying them. There are different salary thresholds that you need to meet in order to classify someone as exempt. You also have to make sure you're complying with certain duties requirements, meaning it's not just a factor of how much you're paying them. It also can depend on what it is that they do for work. And again, there can be some state-specific quirks that you need to be mindful of. For example, it's a lot easier to classify a salesperson as exempt at the federal level, but there are some states that don't have exemptions that would cover sales folks, so you would need to be paying them overtime as well. Hiring practices and at-will employment, these are two, big issues, obviously, that come up when you're first starting to hire in the US. One of the things that's, significantly different if you're coming from Europe or elsewhere in the world is that in the US, the norm and the default is very much that employees are at will, meaning that you can terminate them for any lawful reason, with or without notice, and there are no severance obligations unless you take them on. So it's very important when you're hiring individuals to make it very clear from the start that their employment is at will, that nothing in their employment documents creates a contract. And typically, it's only very senior executives where companies tend to depart from at-will employment and impose, any type of severance obligations or term limits right at the start of their employment. Another thing to be mindful of when you're hiring is that certain jurisdictions have different laws governing background checks and credit checks. If that's something that you want to do, and frequently, particularly in the for financial roles, companies do tend to want to run credit checks. You have to be mindful of state and local laws that can limit your ability to do that. Pay frequency and final pay. These are topics that come up all the time. Certain states have very specific rules about how frequently employees have to be paid. And there are also very strict rules about when employees need to receive their final paycheck if it ends up being that you terminate their employment. In California, again, for example, if you terminate someone, you have to give them all wages owed to them on that day. And if you don't, there are penalties that accrue each day that payment is not made. So whenever you're making a plan that could potentially involve ending someone's employment, you want to make sure that you're taking those things into consideration. The last big topic that comes up a lot is non-competes and other restrictive covenants, like provisions that will prohibit employees from soliciting customers or other employees. These are a frequent tool that employers use, particularly when they're first starting up. But again, there can be very strict limitations on employers' abilities to use these tools depending on where you're located. There has been some movement at the federal level to limit non-competes nationwide. That rule has been struck down by the courts. So we're back kind of in the status quo situation where you need to pay very close attention to what the laws are in your particular state. Again, California, there are a couple other jurisdictions too, are ones where, it's pretty much prohibited from using non-competes with your employees. Other jurisdictions have a little bit more flexible rules. Next slide. Okay, and then just a couple questions to think about when you're building out a people organization. The first is, how many employees do you have and where are they located? A lot of the employment statutes, particularly at the federal level, coverage depends on how many employees you have. For example, the Family and Medical Leave Act, which requires certain employers to provide unpaid leave for medical and family reasons, is only applicable to employers that have 50 employees that work within 75 miles of each other. So you want to make sure that you monitor the number of employees that you have, particularly if you're growing very quickly, because if you cross that threshold, that's the point when you have certain obligations that attach. In a post-COVID pandemic world, there has been a large shift to remote work in a lot of cases. And these days, it's much more likely than it used to be that employers will have employees spread out throughout the entire United States. And with that, means that it can be much more onerous to make sure that you're actually complying with state laws that are applicable in the many states where your employees work. So one thing you might want to consider is whether or not you place any limitations on where employees are allowed to work. How will they be paid? This is, of course, one of the most important things that you have to stand up when you're starting to hire in the US. There are a lot of third-party payroll providers that you can partner with that will make this process a little bit easier and help you figure out what the unique requirements are in your location. There can be state laws that require certain trainings to take place. Illinois is one, for example, that requires anti-harassment training to be given. If you're building out a benefits package, health coverage, dental, vision, life insurance, retirement plans, these are all things that you're probably going to want to work very closely with a third-party administrator to establish, because they can be quite complicated. And again, you want to be thinking about, are there agreements that we want to have in place with our employees to protect things like confidential and proprietary information? So with that, I will hand it back to Baron.
All right, thank you very much. So next topic is immigration, and that will be my topic. I had our business immigration practice here. And this is if you are entering the U.S. market and want to bring over foreign national workers to work in the U.S. In the U.S., probably like every other country in the world, we have a network of laws that tell us how we can hire foreign national workers to work in the U.S., what kind of work visas they need to be able to do so. So we're going to go through the most common options for you to be able to get a work visa to hire foreign nationals here. One is called the L1 visa. This is for an international company that's going to be transferring into the U.S. So an international company means that it is a company that has offices abroad outside the United States that is related in ownership to the new U.S. office or the old U.S. office. So it has both U.S. offices and offices outside the United States that are related in ownership. That's an international company that can sponsor an L1 visa. You can apply for the L1 visa anytime. It is relatively quick to get because you can pay the government to get it in 15 days. And so it can be relatively quick to obtain. There is an L1A for managers or executives that are transferring to the United States, or L1Bs, which are people with specialized knowledge and training that you want to transfer to the United States. Here's what you need to show to be able to qualify for the L1. You have to show that ownership between the foreign entity and the U.S. entity. So show some corporate documents to show the ownership structure. And then you have to show that you have worked outside the United States for that company for at least 1 year out of the last 3 years. So you show some pay stubs to show that you've been paid by the foreign company, the non-U.S. company, for at least 1 year. And then you have been working there in a managerial, executive, or specialized knowledge role outside the United States. So you show an organizational chart to show that you've been a manager, an executive, who you've been managing, if you've been managing people. And then you show maybe a bunch of other documents, emails, for example, or performance evaluations, showing that you've been doing managerial or executive type tasks, such as signing contracts for the company, or assigning assignments to other people on your team, following up on assignments, evaluating the performance, being involved in hiring or firing, or approving time off, those kind of managerial tasks or executive tasks. And then you'll show the same thing that you come into the United States to do, a similar type managerial or executive role or specialized knowledge role. So you show an org chart showing what the U.S. role will look like, where you're going to be on that chart, who's going to be above you, who's going to be below you, are you going to manage people while you're in the United States? And you can manage global people, because everyone knows now the world is a global workforce, and people manage people everywhere they are. People work remotely, so U.S. people can work in the U.S. and manage personnel outside the United States. It can be a new office L1. So if you're starting a brand new office in the United States, you would go for the new office L1, which means it's a new U.S. company that has been operating for less than 1 year. So you show the same stuff we just talked about above on the slide, but in addition to that, you show 2 more things. You have to sign a lease in the United States for office space, a physical office space. It can be a shared office space, but it has to be a physical office space. The U.S. Immigration Service does not recognize a fully remote workforce for the L1 purposes, so you do need to sign a lease, and you have to show a business plan that goes through the general things you would go through in a business plan, your marketing strategy, your financial projections, your staffing projections, what services and products that you might be providing in the United States, that kind of service, so that they know, the Immigration Service knows you're serious about this new business. And then you can apply for a new office L1, get it for 1 year, and extend it up to 7 years. You can remain on foreign payroll. That is often important for foreign national workers in the United States because often they are invested in the social welfare system outside the United States, like maybe there's a pension or there's other benefits that they've been invested in their home country. They don't want to leave that. So you can stay on foreign payroll and stay vested in that system there. You can get it up to 7 years in duration. And a big benefit of the L1 is that you have a streamlined, faster path to a green card. An L1 visa, it's a temporary work visa that you can get for up to 7 years. A green card is indefinite authorization to live and work in the United States for anyone in any capacity. So to apply for a green card, usually there's 3 steps. The first step is usually called the PERM application. If you have an L1, you can skip that first step. You can skip the PERM, and that is a significant savings in time and money to the employee and the company. Another benefit of the L1 is that the spouse, called an L2, can work immediately upon landing in the United States. That is very helpful because you have a second income in the house if you want it. Probably the second most common way to start a new business in the United States is an E1 or E2 visa. It's a trader. E1 is the trader visa. E2 is the investor visa. This one, you can be self-employed. You can start a brand new business here and be self-employed. A lot of other visa categories you cannot. So this is one of the main categories where you can be self-employed and start your own business. For the trader, you have to show that at least 51% of the trade that you're going to be doing in the United States is with the treaty country. So the e-visas are all governed by treaties between the United States and the home country. There has to be a match between the ownership of the company. At least 51% of the company has to be owned by foreign nationals of the treaty country. And the worker has to be from the same treaty country. So for example, for Germany, at least 51% of the company has to be owned by German nationals. And the E1, E2 visa applicant, the worker that wants to apply for the e-visa, has to be a German national. The company ownership has to match the nationality of the worker that wants to come over on the visa. So you show with corporate documents that at least 51% of the company is owned by German nationals, which has a treaty with the United States. And you show with a passport that the visa applicant has a German passport and they can come over applying for the e-visa. For the trader, if it's a trading company, trading goods or services, at least 51% of the trade has to be with Germany. If it's an E2, then you have to show that at least that a substantial amount of money has already been invested before you even apply for the e-visa, to apply for the e-visa. So that means that substantial is not defined in the regs, but what that means in practice is that the government will be looking to see that you're serious about the U.S. business. To show your seriousness, they look for a substantial amount. Substantial in practice usually means $75,000 or $100,000 has already been spent in establishing the U.S. business before you apply for the visa. So the way you do that is show an investment chart showing line by line by line every amount that you have spent in setting up the U.S. business, how much it was, what it was for, how you paid for it, the receipts for it, and then the source of funds. The government also wants to make sure that all of the money you're spending is from lawful sources, not criminal activity. So they ask you to trace back where you got the money from. So you show where the money came from. Did you sell property to get that money that you're using? Did the foreign parent company give you money to use for that new U.S. office? Did you cash in some investments to pay for the U.S. investment? So you do a lawful source of funds analysis as well, and to show that this is all from lawful activity. You initially get the e-visa for up to 2 years, can be extended technically indefinitely. However, every time you apply for the e-visa at the U.S. consulate abroad, you have to sign a statement saying that you have a temporary intention to be in the United States, an intention that you will leave at the end of your e-visa, that you don't want to be here forever, which means you're not supposed to apply for a green card while you're in e-visa status. It also means that although the law says you are technically allowed to extend the e-visa indefinitely, probably year 8 or 9, they might start questioning whether or not your intention is truly temporary, whether you truly do intend to leave to go back after the end of your e-visa. So it may not in practice be as indefinite as they say in the regulations. You can apply in 2 ways. Typically, you apply both. You can come here in one status, such as, a student visa or some other visa, and then do a mail-in application with the Immigration Service and change your status from whatever your current status is in the United States to an e-visa holder. And that change of status will give you immediate work authorization while you stay in the United States. But only work authorization. If you also want travel authorization, you have to apply for the visa abroad at a U.S. consulate or embassy abroad. So typically what you would do is apply both the mail-in application for the work authorization as well as the visa application for the travel authorization at the same time. Spouses also get e-visas, and they are allowed to work immediately upon landing in the United States as well, which is similar to the L visa, and that's helpful. This category of visas are the next most common. However, you cannot be self-employed in any of these visa categories. You cannot be self-employed as an H-1B, E-3, or TN visa holder. All 3 of these visa categories have the same criteria. They are for professional level jobs that require at least a bachelor's degree, and you have the required bachelor's degree. So it's pretty easy criteria to meet, but you cannot be self-employed, so then it's hard to use for a new U.S. business that you are establishing. One structure that has been allowed is if you can show with corporate documents that you are not truly self-employed. There is a board of directors above you that has full power and authorization over the company and your employment. They can fire you so that you are not self-employed. There's someone above you that has say over your employment terms and conditions and whether or not you'll be employed at all. You could do that and then apply for an H-1B, E3, or TN. The H-1B is the regular work visa category that is a bachelor level job. The E3 is the same category, but only for Australian nationals. The TN is the same criteria, but only for Canadian and Mexican nationals. H-1Bs are limited in the number that we issue every year, and we have many more applicants than spots allowed. So they do a lottery every March. You can apply for the lottery once a year. It's every March. And then they do a lottery in March. You will find out by the end of March if you are picked in the lottery for an H-1B visa. And if you are, then you put in your full H-1B application, and the earliest start date you can request is October 1st of that year. So an H-1B visa can be an option for you, but there can be a wrinkle because the time that you want to be here may not be fast enough. The earliest H-1B start date you'll be able to request is October 1st of that year. So A, you have to get through the lottery. B, you're not going to be able to start until October 1st. So that may not be a good fit for a lot of foreign nationals that want to get here and start working. The E3 and the TN, E3 only for Australians, TN only for Canadian and Mexicans. No lottery, you can apply anytime. And you can apply without any lottery, and there's no limit on the time, the number of applicants that you can issue each year. Another area within immigration that is important for new U.S. employers is this I-9 requirement and anti-discrimination rules. Alex touched upon a little bit, but we'll talk about a little bit more here. The federal law, the U.S. law requires every U.S. employer to fill out an I-9 form within the first 3 days of work for every single paid employee. Doesn't matter where they're from, doesn't matter the level of their job. Every single U.S. paid employee has to fill out an I-9 form within the first 3 days of employment. And that I-9 form requires the employee to show with documents, original documents, 2 things: proof of their identity and proof of their work authorization. So for example, a passport, a U.S. passport will show both identity and U.S. work authorization. A lot of foreign nationals have a foreign passport, and an I-94 entry record, their record that shows they entered the United States in a work visa category. So they can show that to show identity and work authorization. A lot of foreign nationals have an EAD card, Employment Authorization Document, EAD card, and it looks like a plastic driver's license with a photo on it. So that shows their identity and their work authorization. So whatever it is, there's a list that the I-9 form has, a list of acceptable documents it's called. You get that list of acceptable documents, you pick whatever documents you want from that list and show those two things and fill out the I-9 form. You cannot discriminate by federal law and state law. You cannot discriminate against any U.S. worker that is coming here. Let me close this out. Sorry about that. You cannot discriminate against any worker that's coming here to the United States based on their ancestry, race, citizenship, national origin, or any other protected class. So if they come and they say that they are from a certain country, you cannot choose not to hire them. You can't fail to hire them based on their country of citizenship, or their national origin, or their ethnicity, or their race. So there are a whole web of anti-discrimination laws that is designed to protect against that. It also means that you have to be careful about what questions you ask during the hiring process. When you're interviewing someone to see whether or not you want to hire them, you should be careful about asking about their citizenship or their national origin or their race, because if you decide not to hire them later, they may think it was because of those categories. Some other considerations, export control considerations. So there are some areas where if you are a foreign national worker working in the United States and you're working on highly regulated infrastructure or technologies, there are limits on who's allowed to touch those and have access to those. And so you'll have to make sure you get a license from the government if you're from one of those countries or you're dealing with one of those technologies to make sure you're allowed to have that access. Customs considerations, especially if you are bringing over goods, you want to make sure you're dealing with the U.S. Customs and tariffs and taxes in a way that is beneficial to you and compliant with U.S. federal laws. There's also forced labor enforcements. So the government has restrictions on using goods or parts of goods that are coming from countries that have forced labor and youth labor and cheap labor. For example, China. We have some restrictions that deal with China. So if you always want to examine where your goods are coming from and where the parts of the goods are coming from to make sure they're not from sanctioned countries. Intellectual property considerations. You want to make sure that any of the goods and services that you are developing in the United States are protected, or the goods or services that you developed abroad are protected while you're in the United States. That's intellectual property. So it's something that you paid for, that you developed, it's your property. You want to make sure no one else steals it and copies it or uses it without your authorization. So there are ways to protect that and have agreements to do that, and actions to sue people that you think are stealing your property or using your property without authorization or copying it. Real estate considerations, who should sign the lease? We were talking about the very beginning. I think Paul was saying that the company should probably be signing the lease so that you are protected against liability against the individuals versus the company. Make sure someone's reviewing the terms so that it's fair to you, the company, and not just the landlord. One other area I want to bring up before we do some questions is insurance. In the United States, there is a lot of different kinds of insurance that companies can obtain to help make sure that if there's any problems in the future, they can get protection from companies to help pay out any liability that arises out of those problems. So there are things like general liability insurance, product liability insurance, directors and officers liability insurance, employment practices liability insurance. So the best way to deal with this topic is to get an insurance broker who can talk to you about what your company could benefit from in terms of insurance policies. They will decide based on the size of your company and what kinds of goods and services you're going to be handling. And so, a prediction of what kinds of problems you might be facing given the goods and services that you're going to be dealing with. And they can give you a recommendation for what kinds of insurance might be helpful for you. You have on your slide in front of you now all of our contact information. There are QR codes to our bios there and our contact information there as well. If you would like to scan that in and save it for future reference or take a picture of the slide for future reference. Now let's go through some questions that have come in. I'm going to look through the QA feature and the chat feature, but if there's any questions that we can't get to today, or because they're too case specific, we can handle them offline as well. Will CLE credit be available for this webinar? We did not set this up for CLE credit for this webinar, unfortunately. That is a good suggestion. Maybe we'll look into that for future webinars. This is a question for Alex. Should a company have a handbook of policies?
So generally speaking, it is a very good practice to have a handbook. And there are some state jurisdictions where you are actually required to maintain, in particular, anti-discrimination and anti-harassment policies. Even in jurisdictions where that's not a requirement, it is still very helpful in the event that you ever have to defend against any type of a discrimination or harassment claim to be able to show that you did have a policy prohibiting that type of conduct. So that is certainly recommended as a best practice. It is also very helpful to have policies in particular that address overtime and working after hours. If you have a large part of your employee population that is non-exempt, meaning you are obligated to pay them overtime for any hours they work over 40. It's very important to have policies setting expectations, about if employees are working overtime, for example, they have to get pre-approval from a manager. In an increasingly remote world, if you have employees who are working from home, you want to be very clear that, if they are checking emails after hours, that is compensable time and they should be recording that. So there are some certain core policies like that, that it's very important to have. Beyond that, the extent to which you have a broader, more extensive handbook really can be, case specific, depending on the specific needs of your business. And sometimes those needs can be changing as you continue to grow.
Thank you. There's a question about whether or not you have to do an I-9 form if you come to the United States with an L-1 visa. The answer is yes. Every single paid employee in the United States needs to have an I-9 form. Does not matter your visa status, does not matter your citizenship status. So U.S. workers, U.S. citizens have to do I-9 forms. Every single paid worker has to do an I-9 form. Doesn't matter the visa status, which also brings up another question. Can you work in the United States without a visa if you're going to work remotely for your foreign company? You may not. If you are in the United States, if you are physically in the United States, if your feet are on U.S. soil, you need U.S. work visa to work here. You cannot be here and think that you don't need a visa because you're really working for your foreign company, the non-U.S. company, remotely. You still need a U.S. work visa if you're going to be physically in the United States. One last question, and then we'll turn it over to Germany. Alex, it's for you again. Are U.S. employers required to have vacation and sick time days off?
So this is a question where it becomes very important to make sure you understand what the state and local laws are that apply to you. At the federal level, there really aren't any paid leave requirements. There are some unpaid leave requirements, but the state and local level is where you do see some jurisdictions that require things like paid sick leave. That's not just at the state level, it can be at the local level. Illinois, for example, is a jurisdiction that very recently passed a law. It's called Paid Leave for All Workers, and that is just a general leave requirement. Typically, when you're seeing leave statutes at the state level, they are specifically for sick or illness-related purposes. But Illinois is a jurisdiction that has a leave requirement that employees are entitled to, regardless of the reason for why they need to take the leave. There are also, for kind of longer term leave situations, there are some states that have paid family and medical leave statutes that can require employers to provide much lengthier time off. Most typically in the parental leave context, but also for just general medical reasons that are qualifying, either for the employee's illness or a family member's illness. But one last thing that's important to remember is in a lot of jurisdictions, you are obligated to provide the leave that you have volunteered to provide. So for example, if you have an employee handbook that has a paid time off policy that says, I am going to give employees 10 days off per year, you are obligated to comply with that policy since you are the one who set it in place. And employees can have a wage claim against you if you fail to comply with your own policies.
All right, very helpful. Thank you, everybody from our US side. With that, I'm going to stop sharing my screen so that Dr. Michaela Filissiak can share her screen, and she will launch the same kind of presentation from the German side.
Thank you, Baron. That was awesome. So let's see. I think you guys should see my presentation now. Does it work?
Yes, we can see it.
Yes, we can see it, I guess.
Okay, great. Thank you. So as you said, Germany is an incredibly attractive market for businesses, but navigating through the legal and regulatory framework here can be quite complex. That's why we have a fantastic panel of experts with us today who will guide you through the essentials. Let's begin by discussing some corporate issues when doing business in Germany. To provide us with an overview of the legal forms available to businesses in Germany and the steps involved in incorporation, I'd like to turn it over to my colleague Martin Samfleben, who is specialized in this section. Martin, what are some of the most common legal structures international businesses choose when entering the German market?
Yeah, many thanks, Michaela, for the introduction. Happy to start this webinar from a German corporate perspective. I'm working at the corporate M&A department in the Munich office for more than 10 years now, and focus on the incorporation of companies, acquisition of companies doing cross-border M&A deals, restructurings, and general corporate law. So doing business in Germany from a corporate law perspective means that there are in principle two options to start a business. You can incorporate a company here in Germany, of course, and start a completely new business, or acquire a already existing business in Germany. So when you choose the first option and incorporate a new company, then of course the question is, what is the right company form? There are many different company forms existing here in Germany, partnerships, limited partnerships, limited liability companies, stock corporations, and many other forms. The decision which company form is the right one always depends on the specific circumstances of the case, of course. However, in many cases, the form of a limited liability company, a German GmbH, is chosen due to the fact that the corporate governance is pretty easy compared, for example, to a stock corporation. If the decision has been made to choose a limited liability company, then the next question is how to incorporate that company. There are, in principle, again, two options. You can incorporate a completely new company from scratch, or you can acquire a shelf company. We always recommend to acquire a already existing shelf company. The reason for this is that when you incorporate a company from scratch, you do not have a bank account at the beginning, and going through the KYC procedures of the bank can be pretty burdensome and take a lot of time, sometimes weeks or months. The advantage of a shelf company is that this shelf company already has a bank account with share capital on it, so you don't need a completely new bank account before starting the business here in Germany. You can, of course, when you decide to acquire a shelf company, afterwards change the bank account to the existing bank with which you are usually working in the US, for example, but that's not mandatory necessary. So if you decide to acquire a shelf company from a shelf company provider, then you usually need to pay the minimum share capital in the amount of 25,000 euros plus a service fee to the shelf company provider, which is in an amount of 4,000 to 5,000 euros. So approximately 30,000 euros will be the purchase price for a shelf company. We will then need the relevant documentation, powers of attorney, small share purchase agreement, and some other details. What shall be the new name of the company? Who shall be the managing directors, etc. And once all of those documents have been executed here in Germany on the basis of power of attorney, we can file the changes with the local German commercial register, and the changes can be registered here in Germany. And once that has been done, you can, in principle, start with your business in Germany. You can sell products or whatever your business shall do here in Germany. The other option, as always, is to acquire a already existing business here in Germany if there is the opportunity to do so via a M&A transaction. The beginning of this transaction is usually that the bankers have the first discussions whether there are opportunities in Germany, and then only at a later stage the lawyers come into the game. Non-disclosure agreements will be executed. And then there are a couple of points which ideally should be clarified at the beginning of the transaction process. First thing is foreign direct investment control. You may have heard of that. Also in Germany and in Europe, a lot of jurisdictions are protecting their businesses which are critical for the relevant jurisdiction. So if it is intended to invest in a business, for example, in the defense sector or in critical infrastructure, then it may be required to get the approval from the Federal Economic Ministry here in Germany. So it should be clarified at the beginning if the business is a critical business and whether any governmental approvals will be required, because that can take a lot of time. The second point is the competition clearance. If the buyer already has a business in Germany or in Europe in the same sector, it should be clarified at the beginning whether competition clearance is required in Germany or other jurisdictions in the world, or from the European authorities, because that can also take some time or require the divestment of other businesses of the buyer in the worst case. When those points are clarified, then negotiations in a lot of cases have already started of the share purchase agreement or the asset purchase agreement. That always depends on the specifics. Sometimes only certain assets shall be sold. But in most of the cases that we are dealing with, the shares of a limited liability company are sold. And it is important to know, once you have a final agreement, you cannot just sign the agreement in wet ink or with DocuSign, but you have to go to a German notary to transfer the shares of the limited liability company. The notary reads out aloud the complete purchase agreement, which can have 100 pages or more. And it takes a lot of time, the notarization process. But that is required in order to have a valid share transfer, at least for the limited liability company here in Germany. And then there may be, as I mentioned, some closing conditions, for example, competition clearance or approval on FDI. And other conditions. And once closing has taken place, the shares are transferred to the buyer, and you can work with a new company which is owned. You can appoint new directors in the new company. You can give instructions to the new company and do the business here in Germany. So I hope that this was helpful for you. And I now hand over to my colleague, Tore, to give some tax background in Germany. Many thanks.
Thank you, Martin. This was very helpful.
Yeah, thank you, Martin. Indeed. Thank you for providing the basis for tax law, which is corporate law, of course. I mean, it's always the corporate guys first, and then it's the tax guys that jump into this. Welcome from my side as well. I have the pleasure to provide some, first insights, an overview of the most relevant taxes that apply to the startup of a German business. It's not only taxes I want to mention, it's also concepts I want to mention, because I think it is important to understand the main risks associated with taxation and those concepts in Germany when starting a business. And risks is actually the right word, because Germany is not only a high tax jurisdiction, it is also, in my view, a high tax risk jurisdiction. That is due to a very formalistic approach of the German tax authorities in relation to subjects such as value-added tax, VAT, tax audits, transfer pricing, certainly compared to the view of the US tax authorities, and certainly in relation and in comparison to the US overall approach to tax law. This is something we are experiencing in various tax audits. Tax audits in Germany are taking place on a regular basis. So any business establishing itself in Germany must be aware that in the course of 4 to 6 years, it will be audited on a permanent basis. There is almost no way around such a tax audit. And in such a tax audit, that may apply to particular forms of taxation, so particular income taxation or trade taxation tax audits are performed, or even to wage taxes or VAT. This is something that happens on a permanent basis, and that will come. And in those tax audits, the overall tax situation of the last years is assessed. So this is something that every investor coming to Germany should be aware of. Germany is not applying a self-assessment system, but it is really that the tax authorities look into this and check the actual tax situation. In relation to business taxation, and in particular to the taxation of business profits, one has to distinguish broadly in Germany between income taxation and trade tax. Trade tax is a special form of taxation in addition to our income tax system. It also somehow applies to the profits of an undertaking, of an enterprise or of a business. And it is also some form of income taxation, but strictly speaking, we are not referring to this as an income taxation in Germany. Income tax is levied from corporations, from partnerships, but not from partnerships themselves, but from the partners of the partnerships, or from individuals. For corporations, income tax is in the first place corporate income tax of 15%, and in addition to those 15% of corporate taxation, a trade tax applies that ranges on average in Germany between 14 and 16%. Partnerships are, as I already mentioned, tax transparent, as in the US. They are not themselves subject to income taxation, but it is the partner and the quality and the kind of the partner that determines the kind of taxation, whether it is personal income tax that applies to the partners or whether it is corporate income tax that applies to the partners. Tax is assessed at partnership level, but the actual taxation takes place at the partner level. And in relation to trade tax, the partnership is a taxpayer, and there's a certain credit mechanism how double taxation between trade tax and certain elements of the income tax system are avoided. Individuals, we also have the concept of the sole proprietorship in Germany, where a business in which a business is performed or can be performed by individuals. These sole proprietorships are subject to, or the individual is subject to, ordinary personal income taxation, and in addition to that, also subject to trade taxation. Again, there's a credit mechanism that applies and that almost completely removes any form of double taxation between trade tax and income tax for sole proprietorships. The concepts that need to be mentioned, or the other taxes that need to be mentioned, because they are really the high risk tax things in Germany, are definitely real estate transfer tax. So a tax on the sale or even any transfer, any kind of disguised transfer even of the sale of real property. Withholding taxation on royalties and on dividends, very important for corporate tax payers and for their shareholders. Wage tax, which is a business tax because there is an obligation to withhold from the wage payments, from the salaries, the tax for the employee and transfer it to the tax authorities. The problem there is that the business and the company as such can become liable for anything that goes wrong in relation to wage taxation. This is why it is considered a business tax. VAT is a classical European thing. That is something that has to be dealt with when investing in Germany or in the European Union overall, and when supplies of goods and supplies of services are made. And then there is the last thing that needs to be mentioned. There's transfer pricing rules. Can we go to the next slide, please?
Sure.
The first question always is that is when tax advisors are approached in Germany, the question arises whether it should be a corporate entity or a branch of a foreign corporate entity, or whether it should be a partnership with which the business should be started. And the answer, as always, is tax lawyers are also lawyers. The answer is it depends. One has to look into the needs of the individual business and also on the possibilities to create certain facts, to create substance, for example, on certain levels of the structure in order to decide which structure would be the ideal structure for a certain investment and for a certain business and type of business. In general, one can say a corporate entity, like the first example here on the left side, a GmbH is this is the typical form in Germany of investment. This is what Martin already described, is taxed with a corporate income tax rate of 15%, as I already mentioned. But in addition to that, there is the solidarity surcharge of 5.5% on the corporate income tax assessed. So that's another percentage, 0.8%, that needs to be added to the corporate income tax. And then there is the trade tax. It's really on average between 15 to 16%. And the important element to be mentioned in relation to corporate taxation is really the dividend distributions, because those dividend distributions are, as a rule, subject to 25% withholding tax. So any dividend distribution to the foreign corporate shareholder is subject to dividend withholding tax. And the mechanisms for avoiding that withholding tax and double taxation in that regard are only available if enough substance exists at the level of the shareholder. This is not a question that one has to deal with if a branch of a foreign corporate entity, the second option here, is established. But in that relation, the allocation of profits, of taxable profits between the branch and the foreign corporate have to be taken into account. The third option of investing in Germany is usually the German form of a limited liability partnership. It is the form in the German mid-cap sector that is used by family-owned businesses because it's so flexible. It's way more flexible than the corporate entities. In fact, you are having a partnership for tax purposes which is transparent and which has features of both limited liability of the corporate entity and the permanent establishment treatment of the permanent establishment of the branch. I think we can go to the next slide. Wage tax, as I said, is a business tax issue. It is actually an income tax of the employee, but still through the way of levying it in Germany, wage tax is definitely a business tax issue. Wage tax is deducted from the monthly salary and paid to the tax authorities by the German employer, there is a liability of the German employer to do that correctly. And if anything goes wrong, it is usually the employer that has to stand in for this. And only occasionally there is the possibility to get anything back from the employee. Again, there one needs to mention there's regular wage tax audits in which the tax situation is assessed, and that is a high risk that everybody should be aware of before entering the German market and starting to employ employees. Can we go to the next slide? Real estate transfer tax is the next big thing in Germany. It's something that is, yeah, can be a huge and a large risk for investors in Germany because it has certain extraterritorial applications. It is not only the acquisition or sale of a real estate property that may lead to a RET liability in Germany, but even, and this is the example I'm showing here on the slide, even a group reorganization way above the chain, way up the chain, can lead to a RET obligation in Germany because Germany perceives the share contribution, for example, as a disguised transfer of the real estate property. That brings us to the last slide, or my last slide at least, in relation to VAT and transfer pricing. It is that Germany applies the general rules that are applicable in the European Union in relation to VAT. So one has to be aware that all supplies of goods and services between taxpayers are subject to VAT. Usually there is certain exemptions, very technical, but this is something one is facing when entering Germany. The VAT rate is 19%, the reduced rate is 7%, to compare that to other European countries probably. Also there, it needs to be mentioned, it is a very formalistic approach that the German tax authorities take, which leads to a lot of controversial issues. Similar in transfer pricing, Germany, as an OECD member state, is applying the general rules, the framework provided by the OECD in relation to the arm's length principle. So yeah, the obligation to price intercompany dealings cross-border at a market price, basically. But also that Germany handles a very formalistic application, and it moves into risk transaction or transactions perceived as risky in relation to financing and to intellectual property, because there Germany perceives that there is a lot of possibility to shift profits somewhere where they don't belong. This would have been my brief overview on taxation.
Thank you, Tore, for shedding light, let's say, on these always very difficult tax complexities. In our day-to-day business, we can't do anything without you and the tax advice. Another very critical element for any company doing business in Germany is the employment law framework, especially given Germany's very, very strong employee protections. Here to guide us through some key aspects of German labor law is my colleague, Stefan Steger, who is specialized in this area. Stefan, what are some of the fundamental labor law regulations foreign companies should be aware of?
Yeah, good evening from Düsseldorf, where we have a weather warning right now, but I'm in the office, so this should not affect this. Yeah, we picked out some specific topics which are usually asked when one wants to start a business in Germany. So the first thing is that we have specific forms of employment. So aside from the employment contracts for an indefinite period of time, there are two types of fixed-term employment contracts in Germany. On the one hand, there is a fixed term according to the calendar. This means that we have a fixed end date written in the contract and a fixed term established by the purpose of employment. This means the fixed term is based on a specific purpose. Yeah, the fixed term employment according to the calendar is permissible for up to 2 years and no longer, and fixed term employment established for a purpose is permissible for longer than 2 years. The law regulates the grounds why such a fixed term employment can be set up. For example, that the employee is substituting another employee due to sickness or sickness and parental leave, for example. Any fixed term employment contract must be in writing, and the contract has to be signed before starting the employment relationship, because if the employee, for example, starts to work and there is no written document, it's a contract for an indefinite period of time. So those are the hurdles one needs to be aware of. Then usually we get asked about background checks. This is typical in other jurisdictions. And even in Germany, employers are generally free to check employment reference and other informations represented by job applicants. This can be done by inquiries to third parties, in particular former employers. However, the applicant has a constitutional personal right, and we have EU and federal data protection laws, and they have to be considered in terms of privacy and protection of personal data. This means that the future employer might ask before he calls the former employer during a process. Really specific in Germany is the institution of the Works Council. They are set up in companies when the legal requirements are fulfilled. A Works Council has a wide range of rights, which are set out in the Works Constitution Act, called the Betriebsverfassungsgesetz in German. And some of the most important rights are the right to information, means that the Works Council has the right to be informed by the employer in a timely and comprehensive manner about all matters concerning employees. This includes economic matters, personal planning, and working conditions. Then the right of participation. This includes the right of consultation, co-determination, and initiative. The Works Council can make proposal and must be consulted on certain decisions. For example, if the employer wants to shut down the business. The rights of co-determination. In certain matters, the Works Council has the right of co-determination, which means that the employer cannot make any decision without the consent of the Works Council. This applies, among other things, to working hours or vacation regulations or the introduction of new technologies in a branch. Then the Works Council has, in certain cases, a veto right in personal measures, such as recruitment, transfers of employees, or dismissals. Then the Works Council has the right to demand measures to protect employees, such as healthy and safety measures, or measures to promote equality. The Works Council members have the right to be released from work during the time they are carrying out their Works Council activities without a reduction in pay. So this means that they are not productive during that time, but they still get paid. And of course, the right to training. The Works Council usually are not lawyers, so they have the right to take part in trainings that are necessary for their work. And usually most of the Works Councils think that they have studied law, so they are behaving like they studied law in the past. But yeah, they get their knowledge in workshops they are visiting. if the employer is not, let's say, if the employer is not respecting those rights, and the Works Council and the employer have a dispute, the Works Council can enforce its rights in court at the employer's expense. So the rights of the Works Council should be seen and not overstepped. Yeah. For compensation, since 2017, we in Germany have the Act of Minimum Wages, and the minimum wage right now is 12 euro and 41 cents per working hour. The minimum wage generally applies to all industries and private and public sectors. In addition to the Act of Minimum Wages, the wage is often specified in collective bargaining agreements between employers and unions. And these agreements are binding for employers if they are a member of an employer association or if they have negotiated bargaining agreements with the unions on their own without the employer association. We call that a Haustarifvertrag. Collective bargaining agreements can be declared generally binding by government order. In this case, the agreement is binding for all employers and employees in the particular industry. For example, we have this in Germany for the cleaning industry. And the minimum wage also applies for employees of foreign companies operating in Germany, regardless if the foreign company has an office or site in Germany or not. If a collective bargaining agreement starts a higher minimum wage than the statutory one, the higher wage is binding and the employer may not cut the higher wage. And any agreement cutting, excluding, or ignoring the minimum wage is legally void and not enforceable. Violations may be punished with a fine up to 500,000 euro, and in addition to the employer, the instructing entrepreneur is liable in such cases. With regard to working hours in Germany, under the Hours of Employment Act, Arbeitszeitgesetz, a working day should not exceed 8 hours in total. The employees may work up to 10 hours per day, but within 6 calendar months or 24 weeks period, the average working hours per day should not exceed 8 hours. Employees who have worked more than 6 but fewer than 9 hours in a workday must be given a break of at least 30 minutes, and those who work longer than 9 hours must be granted one 45-minute break. And during 2 working days, there has to be at least a 11-hour break. So working on Sundays and bank holidays is generally not permitted. The Hours of Employment Act includes various exemptions to provide flexibility in the medical care, health, and restaurant industry. Of course, the hotel industry too. The next topic would be parental leave. The Maternity Protection Act, Mutterschutzgesetz, excludes women from performing certain tasks during their pregnancy and for 8 to 12 weeks following the birth of the child. A pregnant employee does not have to work during the last 6 weeks before the expected birth of the child. And under the Federal Parent Education and Parents Allowance Act, parents of a newborn child can claim up to 3 years of unpaid time off to take care of their child. This total time off can be claimed by the mother and the father simultaneously or individually. Employees who take the time off are permitted to work up to 32 hours per week in part-time. They can work for the employee they are hired or for another employer they are hired or for another employer. Regarding to sick leave, we had this question before for the US law. In Germany, employers have to provide employees with 6 weeks of paid sick leave for each illness that result in incapacity of work. The sick leave pay is regulated under the Sick Pay Act, Entgeltfortzahlungsgesetz. That's a long word, I know. Employees are required to inform their employer in due course if they are incapable of working and also how long such incapability may last. Employees with 3 days of sick leave must produce a written medical certificate no later than the next, means the 4th day of incapability, attesting to the illness. And following the 6 weeks by the pay by the employer, the employee will receive sick allowance by the health insurance in the amount of 70% of their last salary for another 72 weeks. So in total, 78 weeks of sick pay. So I would like to come to the last point. We have chosen termination. In Germany, it is possible to terminate employment contracts with or without notice with immediate effect. The respective minimum notice periods can be found in the Civil Code, BGB, collective bargaining agreements, and of course the employment contract itself. The statutory notice periods increase with the seniority of the employee, and the Protection Against Dismissal Act protects employees against wrongful termination. In this act, a termination is permissible for the following causes: personal reasons, conduct, or business reasons. The German labor courts have ruled that a valid termination based on inappropriate conduct requires a prior warning by the employer and a continued inappropriate conduct by the employee after the warning. A termination based on a personal cause is often a result of illness of the employee and requires that for the future it's predictable that the employee still remains sick for a long period of time for each year, and that the employer has to bear the wage without receiving work for this wage. Termination based on a business reason requires, for example, that an employer's decision to restructure that business in a way that certain jobs or positions in the organizations are not longer needed. In the second step, there is a process called social selection. In this process, the employer has to identify who among the employees should be given notice if more than one job or position is redundant. In the process of social election, the employer has to consider the following factors for the employee: seniority, age, number of dependents or family maintenance obligations, and, if any, disability. And the employee with the highest factors will keep the job, and with the lowest factors will lose the job. This in the end results that usually the younger employees, which should stay, they are the ones that have to be released. So this has to be planned in advance in the right way. It is important for employers in Germany to know that an employee who brings legal proceedings in front of a labor court claiming wrongful termination may be entitled not only to reinstatement to her or his former position, but also to payment of outstanding salaries. The employee can claim remuneration for the months during which she or he did not receive her or his salary because the employer thought that the employment relationship had been terminated. So this, if a process lasts for 2 years, 2 years of salary have to be paid when the verdict is final that the employment relationship was not terminated. And as a last point, again, the Works Council, in offices where Works Councils are established, the Works Council must be informed before any employee termination is issued. And the Works Council has 1 week to consider if he has or if they have concerns regarding the intended dismissal and this time period is shortened to 3 days in case of an intended termination without notice. So this is German labor law in a nutshell, just a few topics.
Thank you, Stefan, for this very important overview. I think there are plenty of aspects one can discuss when it comes to employment law in Germany. Just that you guys know, we also included QR codes in the presentation as well as our contact details. So if one of you guys has a specific topic or wants to dive deeper, don't hesitate to contact us. We are happy to help you guys.
Yes.
That leads us to our next topic, immigration, as immigration rules also play a crucial role, particularly when it comes to bringing talent from abroad to Germany. To discuss immigration requirements and procedures, I'd like to welcome my colleague Luisa, who's one of our experts in immigration law. Luisa.
Hi, Michaela. Thank you. And thank you, Stefan, for the introduction to German complicated employment. Yeah, that's true. So let me just give you an overview on the key aspects of German immigration law and the administrative obstacles that are connected with that one. If someone wants to enter and stay in Germany or to transfer to a German employer or company, he or she needs a visa and or a residence permit. And there are different types of visa and residence permits. That types depend on, first of all, on the purpose of the trip and the stay. Is it a business trip? Is it maybe for vacational reasons? Is it a secondment, a transfer, whatever? And then it depends on the length of the stay, corresponding, of course, to the purpose. And finally, it depends on the nationality of the applicant. So, for example, nationals of the European Union, the European Economic Area, and Switzerland are entitled to freedom of movement, and they have unrestricted access to the German labor market. So they do not need any visa or residence permit at all. But in principle, foreigners, and that means citizens of a third country, require a permit. And actually, it does have a very strong impact whether you are planning a shorter or a longer stay in Germany. There's a two-step procedure. First of all, you have to get a visa just to enter Germany. And this visa you get by applying to the German diplomatic representation in your home country. And after the visa is issued, you may enter Germany. However, if you want to stay a little bit longer in Germany, then you might need a residence permit. In order to get that residence permit, the applicant must register his or her residence in Germany, and afterwards, he may apply to the responsible immigration authority for the residence permit. And finally, the residence permit for the stay is issued, and you might begin your planned activities, for example, taking up a gainful employment. Next slide, please. Yeah. First of all, let's have a look at the requirements if you just want to stay for a short time, for example, for a business trip. In this case, you need a Schengen visa. And this Schengen visa allows free travel within the Schengen states. The Schengen area or the Schengen states are basically the member countries of the European Union, except Ireland and Cyprus. However, the Schengen area includes Iceland, Norway, Liechtenstein, and Switzerland. And this Schengen visa allows stays up to 90 days, that means 3 months, within 180 days. However, the applicant must prove that he is able to finance living and travel expenses from his own assets or income. And furthermore, he must present travel health insurance valid for the entire Schengen area and for the entire duration of the stay with a minimum cover of 30,000 euros. However, again, US citizens are privileged due to agreements between the two countries, between Germany and USA. In their case, a visa is not required and a valid US passport is sufficient if the stay does not exceed 90 days within 180 days, and if no economic activities are being pursued. This does not mean original business trips. So you may need a Schengen visa to get on a business trip, However, we strongly advise that you have always an invitation letter from the German company with you. And then there's something new as well. Please note that there's going to be a change regarding the procedure next year in 2025. The ETIAS will be the European Travel Information and Authorization System is going to be introduced. This is quite similar to the ESTA in the US. And it's just a fast online application process for a travel authorization, and is also linked to the applicant's passport, like in the US. Yeah, next slide, please. If you want to stay for a longer term of more than 90 days, then you have to take the 2 steps I mentioned before. First of all, you need a national visa, which is also valid within the Schengen area. So you're allowed to travel free in the Schengen area. And then again, it requires securing living expenses. And finally, this national visa must then be converted into a residence permit. However, we have an exception for American citizens. American citizens may enter and stay in Germany without a visa as before, but they have to get a residence permit finally. But this can be obtained in Germany. So it's not necessary to apply for a residence permit in advance from the US. You can get to Germany, and afterwards you may apply for the residence permit. And there are several types of residence permits. For example, they are for the purpose of training, education, for the purpose of taking up gainful employment, for reasons of international law, humanitarian law, and political reasons. Of course, for family reasons, to reunite your family. And the residence permits can be issued limited or unlimited. And there are special kinds of residence permits for skilled workers with an academic education. These are, for example, the Blue Card EU and the ICT card, which is very interesting for companies. So next slide, please. That's why we're going to have a closer look at these 2 categories. The Blue Card is basically a temporary residence permit for highly qualified workers. And the holder of a Blue Card is entitled to take up residence in the European Union for the purpose of taking up gainful employment. Basically, applicants must have a university degree and then must have been offered local employment in Germany. So they need a German employment contract. And this employment must be in accordance with their professional qualifications. And then in general, the new job must provide gross annual earnings for at least 45,300 euros. However, as you can see on the slide, there are exemptions. Germany is in urgent and desperate need for qualified personnel in professions such as doctors, engineers, scientists, mathematicians, IT specialists, and especially in the area of healthcare and childcare. So in these professions, applicants need a job offer with gross annual earnings of only around 41,000 euros. So you can see the Blue Card is actually the most common residence permit in the area of temporary labor migration due to the quite simple and fast procedure. And it offers a lot of advantages. You can see over there, like for example, you can change your job after some time quite easily. And it is, furthermore, if you fulfill all the requirements, then you are legally entitled to get a Blue Card, which is kind of interesting as well. And finally, Blue Card holders are eligible for an unlimited settlement permit. Those who prove good German language skills, for example, may be granted a settlement permit already after 21 months and can stay in Germany. Next slide, please. Yeah. Another possibility to stay in Germany is an ICT card, an intra-corporate transfer card. The ICT card enables companies based outside the European Union to deploy their employees flexibly in the European Union. So the employee remains an employee of the posting company and is only transferred to a branch office of the same company or group of companies. So he or she is going to keep the foreign employment contract, but might need a letter of secondment or a secondment agreement. For example, if the transfer is not regulated in the employment agreement in the employment contract, or if, for example, German standards like in regard of work safety are not met. The ICT card is a residence permit exclusively for managers. That means people employed in a key position, specialists and trainees. Managers and specialists may stay with the ICT card for up to 3 years in Germany. In case of trainees, the ICT card will be issued for up to 1 year. And like the blue card, it also allows more flexibility within the EU. So you are quite free to travel around in the European Union. Next slide, please. Thanks. Yeah, this was just a quick overview on some of the possible ways to enter and stay in Germany that might be interesting for companies. However, these legal regulations are important not only for the companies, but for Germany as a country itself. Germany, as many other European countries or the Western Hemisphere, is struggling with a high shortage of skilled and qualified workers, which will be exacerbated by demographic trends. We have an overage society. And this is one of the reasons Germany has become an immigration country. And although efforts are being made to reduce the administrative hurdles and to streamline and simplify the process, there are still too many bureaucratic obstacles, as we get to know in our daily business, even for applicants from a friendly country like the USA. And therefore, it is really crucial to plan a trip and stay in Germany and deal with all the requirements that need to be met at a very early stage. Thank you.
Thank you so much, Lisa, for those very valuable insights. Finally, I'm pleased to introduce my colleague, Thomas Farkas, who specialized in IP law and who will give you guys a very quick overview of the main aspects companies have to consider.
Yeah, thank you, Michaela, and thank you everyone for joining. It's a pleasure to speak in front of you. I'm Thomas. I'm an IP attorney IP and commercial attorney since 15 years now, and happy to give you a brief overview of the legal implications. I'm also aware that I'm the last person keeping you from the rest of your day, so I'm trying to be brief. Starting with IP, which is my favorite topic. What is important when you start a business in Germany? Generally we have the main IP rights in Germany that you will know. We have trademark protection, design rights, copyright, patents, unfair competition law, which is a bit specific, and trade secrets. So first of all, clients tend to struggle with trademark protection. So when you try to offer a product or a service in Germany, first thing you should do is obviously look for a good brand or for a good name. You can call your product software solutions. You will not get into any trouble, but it's also not a good brand name, right? So what you have to do is, first of all, check for any prior rights in Germany for your particular brand. You can do that over the trademark register and obviously ask us for help. And what you should also do, you should check for a meaning of your brand, right? Because often companies try to go global, and in German, a word that is great in the US can mean something harsh or something harmful. So you should also check on that. Examples that I have is a product for hair care was called Mist Stick in the US, and mist in German means something you don't want to go there. So you really have to check for that. And for trademarks then, and for all IP rights, another important thought is who should be the owner of such right. So you prepared your trademark, you have your brand name, but who should be the owner? If you're a small company, you could consider obviously that the company is the owner, but to some extent it may make sense that a natural person is the owner of an IP right, especially when the company goes into trouble or into bankruptcy. The trademark and IP assets would not go the same way, but they will still be owned by that natural person. Two natural persons should never hold an IP right in Germany because that's really complicated. Basically, both owners could fight each other and you can't do anything with the IP. So that's the main thing for trademarks. Trademark is the registered right. Usually that's the same as in the US. now turning into copyright, which recently has quite some changes in Germany. So it's even a protection for designs for products, which used to be quite rare. And in the US, I understand it's also rather rare. But the courts have opened this so even the design of products are protected. What's different than in the US is we don't have a copyright register and we don't have a copyright office. So it means any intellectual creation that you will have, it must be fixated, obviously, some extent. Means there's no concept or no protection for an idea, but you have to fixate it and you have to prove that. You don't have an office that proves the date of the creation, but you have to do that on your own. You have to prove that, and a copyright in Germany cannot be transferred as such. So you could only grant rights for exploitation and for use, which is sometimes tricky because you have to prove that you own these rights. The right is not transferable. It always stays with the author. And I guess from what I understand American copyright law to be, that's quite a difference. Design rights, they protect basically the appearance of a product. They're usually rather cheap in obtaining, so the fees for that are rather low. It's quite a good right for that. But you must take into account these rights are unexamined, meaning that the trademark office for a trademark will assess whether the trademark deserves protection or not. With design rights, it's an unexamined right, meaning as soon as you apply for this right, you will get a certificate right away. Only afterwards, in a possible litigation, you will learn whether your creation of a certain product is actually novel and has individual character. Patent, also obviously quite a big topic, especially since we had a big change in Europe. We now have the UPC, the Unified Patent Court and Unified Patent System, which is, to understand it, it's like a European unitary patent right that is quite new. It's quite a good option to obtain, but obviously difficult, and I guess to explain that this would completely take all of my time away. Unfair competition law is quite an important right. It's not to be confused with competition law as such, or I like the name in the US now, sorry. It's not competition law, it's unfair competition, meaning that as soon as some statutory law also regulates market behavior, for example, the way that you have to label textiles or that you have to mark electronic products, as soon as that is governed by the right, you could also violate unfair competition law if that is done wrong. For example, recently, a rather famous German footwear manufacturer claimed that their product is 100% made out of ocean plastic, while in fact the plastic was not in the ocean, it was just close by. And I'm telling you this because this was held to be confusing to the consumer, because the consumer would assume that it's actually 100% from the ocean. And as soon as you have that, you would infringe unfair competition law and the corresponding regulatory law, and obviously could get into trouble. Last but not least, trade secret law from an IP perspective. That's a European law. It's quite still rather new. It's quite difficult to claim this in court, because you will always have the problem of, I need to show that I have a trade secret that's been violated. But if I make the trade secret public in court, then I obviously am able to lose the secrecy part. Here it's important, and I think that connects well with employment law. It's important that not just because you think something is confidential or you mark it confidential, it's not a trade secret. So you have to have reasonable measures to keep things a secret. I think the Coca-Cola recipe is the most famous one, where allegedly only a few people combined together know the complete formula. It's hidden in a safe, etc. So you actually need to have measures like password protection, entry protection to certain rooms, etc., in order to rely on trade secret protection. That's a really, really fast run through IP law. From a commercial perspective or commercial law perspective, what is quite important and with what clients struggle often is regulatory law, meaning that as soon as you set up, for example, a website that addresses the German consumer, you need to be aware that the information on that website is correct, that the imprint is correct, that any way that you deal with personal or sensitive data, any cookies that you use, this must be really correct. And I think the main difference and the main thing that is unknown to people outside of the jurisdiction of Germany is not that any authority could make a claim for this violation, but it's competitors that can do that too. Meaning that as soon as you violate potentially data protection, textile labeling, any advertisement, etc., if I'm a competitor to your company, I can basically claim you had less effort in compliance, you saved money, I have to be compliant, and therefore it's your violation and I can claim damages. I think this is something you really need to be aware of, because this obviously changes the whole compliance setup. Data protection I've mentioned, that's obviously quite a big deal. I think that's too much to discuss at this stage as well. And actually, when looking at time, these are the most important aspects to consider. And it's really get your IP protection right. I know it is quite simple, and you will hear that a lot. But I recently, in course of the Euro Championship, I defended a client because they made an announcement of a certain product, really big product, but they did not protect the trademark. And now we are fighting off a trademark squatter, so to speak, because it was a bad faith application, but it's quite a big effort to do that. So really check your IP rights, check your domains, check any advertisement, whether they can be misleading or not, always keeping in mind the German consumer. And I guess these are the main aspects to be aware of, and happy to answer any questions that you might have.
Thanks, Thomas. That was great. Actually, thank you to all of our experts for sharing their knowledge and their insights. I hope this session has given you a clearer understanding of what it takes to successfully do business in Germany. As we are running out of time, I'd like to point out that in the presentation, you'll find our contact details and our QR codes. So just send us a short email and we're happy to deal with all of your questions. All questions which are in the Q&A section we'll answer via email. So once again, thank you everyone for joining and your participation. We hope that was helpful and we hope to see you again at future events. Have a great day and goodbye from Germany.